Hi, this is Roger Petersen. If you have purchased property in Costa Rica, the most likely scenarios are that you've purchased it in your individual name, jointly with your spouse, or in the name of a Costa Rican corporation. In this video, we're going to look at what happens to the property when one of the owners of the property passes away. The probate process in Costa Rica is what will accomplish the transfer of title from the owner of the property to the heirs designated in their will, or if there was no will, to the heirs designated by law. In Costa Rica, you should not assume that because property is titled 50% with your spouse, that it will automatically transfer to your spouse upon death. The reason for this is that Costa Rica, which is a civil law country, does not have the disposition the common law does of joint tenancy with rights of survivorship, where it's automatic. In Costa Rica, it is not. You will have to probate that 50% over to the spouse. In Costa Rica, a probate proceeding can proceed via a judicial proceeding, which means you simply file a petition for probate with the applicable court that has jurisdiction, or, depending on the circumstances, a notary public may be able to process a probate proceeding for you. This is only available if it's uncontested and there's no minors involved in the probate process. So here we're dealing with what happens to the shares owned by the shareholders of the corporation. The shares of the corporation also become part of the estate. So therefore, if 50% of the shares of a corporation are titled to one spouse, in order for that to transfer to the surviving spouse, those shares would have to be probated in a probate process as well. So if you own property in Costa Rica, it's a great idea to take a look at how the ownership is structured so that you can avoid any hardships to the heirs of your estate.